morning, everyone, and thank you for joining us for today's session, where we will be discussing the Court of Appeals judgment in 89 Holland Park Management Limited and Sophie Louise Hicks, and considering the wide-ranging implications for developers, landowners, and those who represent them. My name is Stephen Smith, and I'm delighted to be joined once again by Ian Quayle and our guest speaker, Tim Calland of Maitland Chambers. Tim represented the successful appellant in enforcing the restrictive covenants in this case. Good morning to you both.
Morning.
Morning.
Just by a brief way of introduction to Tim, he has more than 20 years experience providing advice across the full range of commercial chancery litigation, and he has extensive knowledge of most kinds of real property litigation. He's described in the directories as a superb advocate, able to unlock even the trickiest of legal problems, an unfluffable presence in court, and a detailed, clever, and tough when he needs to be. Tim, thank you for taking the time for joining us today. We're delighted to have you with us. Just before I hand over to Tim and Ian, I just want to go over a few items to let you know how you can participate in today's session. You are listening through your computer's speaker system by default. If you would prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed. The telephone is toll-free, so it shouldn't cost any additional money there. You'll have the opportunity to submit text questions to both Ian and Tim, just using your control panel. You can send questions at any time of the presentation, and we will collect these and address them at the end in a specific Q&A session. You can also raise your hand during the presentation if you're having any difficulties with the sound or any other technical issues, and please do get in touch. We are able to resolve most of these issues, so yeah, and with the rules will also be a recording sent out after. If you would also like to ask questions over your mic and speakers, please do also raise your hand and let us know. You can speak to Tim and Ian directly. So thank you. Without further ado, I'll pass over to Ian and Tim for the main part of today's presentation. Thanks both.
Thank you, Steve, and thank you, Tim, for joining us today. Yes, good morning, everyone. Ian Quayle here from IQ Legal Training. A fascinating subject, this one. Again, really sort of highlighting issues relating to restrictive covenants, and I'm delighted that, given Tim's involvement in the case, that he's along with us today to deal with questions and issues relating to the case. And there's some significant points, in my view, relevant to practitioners, be it transactional property lawyers acting for buyers and sellers of leasehold properties, and indeed those acting on behalf of landlords and reversioners. So there's quite a lot of it, very interesting things to extract from the case. And as I say, I'm delighted Tim's here to join us. What I'm going to do to start today's presentation, before we get to the main event, which is Tim, and I note that Tim has a lot of experience with regard to restrictive covenants and a very sound property practice, as well as an insolvency practice too. So it's brilliant to see Tim and to be able to ask 10 questions about the case. Given his extensive knowledge, what I thought I'd do is just try and put the case into perspective and say, if we are transactional property lawyers, what really do we need to take away from this case, and what it would be interesting to hear from Tim he has to say about some of these points. So the subject matter is 89 Holland Park, and that's a picture of the property. Just saying to Tim earlier that obviously the flats in this apartment are very expensive indeed. And Tim was assuring me that the value of this property as a property about £30 million. So there's quite a lot to fight about. As far as the dispute was concerned, we had Sophie Hicks, who was a renowned architect involved in connection with acquiring land adjoining, and she was quite advanced really in her thought about creating a modern building, perhaps not in keeping with what we're looking at the moment, but quite an interesting architectural design with a sort of bit of basement activity, and I think, as Tim's going to explain, a peculiar glowing cube that seems to be something that got everyone very excited about. So as far as today is concerned, as a transactional property lawyer, what do we really need to know from this case, or what can we extract from it? What did I take from it? Well, the first thing is, if I'm acting for a buyer, and I'm looking at acquiring a leasehold property, then it is important to ascertain if there are any issues that are going to impact on the client's objective with regard to acquisition. If I'm buying a very expensive property in Holland Park, I'm clearly going to be very interested in anything that's happening in the vicinity that's going to affect the value of my property, the structure of my property, and issues associated with my living in the property or letting it out or using it for investment purposes. So therefore, I'm very interested in the objective with regard to my acquisition and the objective sitting behind the covenant. What's it designed to do, and how is that going to impede me with regard to my use and enjoyment? Again, the other point that I think is significant is that we should be thinking about, sorry, I'm just skipping along, we should also be thinking, if we're drafting restrictive covenants, again, about what's the objective of the covenant. And again, from this case, what about future use and owners of the building? What about that? How is the covenant going to impact on that? Because if you look at this case, you had our dear friend Brigadier Radford in 1965 owning a very valuable property, thinking about protecting it and imposing a covenant when he sells a potential plot about what happens to his investment, to his property. At that stage, it's an investment property let on short-term lets, and therefore clearly he's interested in his investment, is in the structure of his property, and also the value of these short-term lettings. He's not thinking about, here we are in 2020 and 2021, high value, long residential leases, and the sort of aesthetics, the interest, the concerns of owners at that point in time. I think if this case highlights anything, it is the fact that if we're drafting covenants, we need to think about future use and owners of the building and how we're going to protect them with regard to the covenant that we're imposing. One of the things I'm interested in, I'll be asking Tim about, is if we are looking at whether or not our conduct in decision making with regard to plans relating to development, should we be thinking about listing potential grounds or reasons for refusal, taking into account any concerns that we've got about the covenant, about future use, about owners, and about our own views relating to the building. And again, I think it's quite interesting, again from the case, looking at it, that we need to take care when drafting restrictive covenants to think about the definition of land or property which benefits from the covenant. Because again, here, and I'm sure Tim will explain this in a lot more detail and a lot more succinctly than I could, there was clearly an issue about, was the covenant protecting the reversionary interest, the freehold interest in connection with the block, or was it designed, or could it be utilised to protect the leaseholders and their interests? So lots of things to talk about. Buyers, what's the objective of the client? Is the covenant going to impede or prevent that objective? Is the covenant enforceable? And significantly, if so, by whom? So if we're acting for the likes of Sophie Hicks and developers, etc., we do need to think about what is going to happen relating to this covenant. Should we be thinking about approaching people who have the benefit of the covenant to see if an accommodation can be reached? But even if we've decided we're not going to do that, it is important that we determine who can potentially react to any breach of covenant, or who can be participating in the decision-making process where consents are required. If we're acting for landlords, again, if we're buying this as the reversionary interest, etc., we need to know about the mechanics relating to consents, relating to covenants. So how should we advise clients in connection with acquisition? And then as far as day-to-day management is concerned, what should we be advising when the likes of Sophie Hicks and other developers approach and say, can we have consent to the works that we're proposing? And how do we deal with aesthetics? And when should we be seeking specialist advice when this sort of problem arises? So in essence, from a transactional perspective, there are lots and lots of issues and lots of interesting things to extract from this case. And therefore, Tim, thanks very much for coming along today. What I'd like you to do, if that's possible, is to explain to us what you conceive the issues are relating to this case, and to provide a bit of background and to set the scene. So Tim, if that's possible, thanks for coming along, and over to you with regard to the issues.
Thanks, Ian. The place I'd like to start is just really with the basic shape of the case. So this was a case concerning a development site next to 89 Holland Park. The development site was part of the formerly part of the garden of number 89, and comprised a small strip running alongside the building from the street back to the buildings below. The development site was subject to a restrictive covenant that was taken at the time of the original division of the properties. The background to the covenant was that it wasn't a simple restrictive covenant restricting building, but there was actually the development site was sold as a building plot with a positive covenant by the purchaser to build a house, the plans of which had already been agreed and approved. And the particular covenant that was taken was not to apply for planning permission for any other development of the site without the prior approval of plans. So the idea was that the purchaser wouldn't just go and build something entirely different. In fact, the property was never built, and the plot had remained empty for decades when it was acquired by Miss Hicks. Now, the basic shape of the covenant, as I've indicated, was not to apply for planning permission without prior approval of plans. So it's that type of covenant, the prior approval of plans type, which many of you, I'm sure, will be familiar with as it arises in all types of restrictive covenants. So the basic problem here was Miss Hicks had drawn up plans for her new property, which was made of concrete and glass, and much of it was underground. And the owner of 89 Holland Park had refused to approve the plans. And so Miss Hicks challenged that refusal on the basis that it was unreasonable. Looking just at the grounds why approval was refused, there were three basic types of grounds. There was first aesthetic reasons. Second, there were environmental type reasons really connected to the amenity of number 89 that were not to do with the aesthetics of the proposed building. And then there were structural issues. Now, the structural concerns happened not to make a huge difference in this case for reasons that I won't go into now, but there was another covenant that was specifically directed at protecting the structure. And so that really fell out of consideration for this particular part of the covenant. Now, the heart of the objections was the aesthetic grounds, and it was clear that objection was taken to the design of the building, and in particular its presentation on the street front as a single-story glazed structure which provided the entrance into the subterranean part of the building. And you can see on the slides the quotes from the reasons given. It's not an attractive choice and clearly an alien feature. Really, it was an objection to what the building was going to look like. So Miss Hicks then brought a claim against 89 Holland Park Management, which was the owner of the freehold, challenging its refusal. So looking now at what happened at first instance, I should say first that the way that number 89 Holland Park was owned was the freehold of the building was owned by 89 Holland Park Management Limited, and the property itself had been divided into 5 flats, which were held on 999-year leases, I think it was, anyway, long leases, so that all that the management company owned was the freehold of the building, so the structural parts of the building and the reversion on the leases. Now, importantly, under the covenant, the party whose approval was required was the management company. It was not necessary under the covenant to seek approval from everyone who had the benefit of the covenant. And the reason why that mattered is it had been established in an earlier round of litigation that the leaseholders had the benefit of the covenant as they derived title under the management company. And so on conventional principles, Section 78 of the Law of Property Act, the benefit of the covenant had passed to them. So at the time of the decision, that's the decision to refuse approval, the sole interest of the decision maker was the structure of the building and the reversion. Now, what the judge at first instance decided was that 89 Holland Park Management, the freeholder, could only have regard to its own property interests when making the decision. And that meant it could not have regard to the interests of the leaseholders because it wasn't their approval that was required. The judge held, as you perhaps would expect, that aesthetic considerations were irrelevant to the freeholder's property interests as the owner of the structure and the owner of the reversion on the very long leases. And so he found that aesthetic considerations were irrelevant. He also found that environmental considerations were irrelevant. Now, just to outline what they were, as you will see, I think in a moment that from a slide, the building plot was covered in a number of self-seeded sycamore trees that screened off 89 Holland Park from the 1960s development to the side and to the rear of the building. And so the leaseholders regarded it as really quite important. You can now see on the slide the trees. So just looking at the building plot, it extended from the brick pier of the front there on the street, just by the entrance to the 1960s block of flats, and extended across to the edge of the right-hand edge of the entrance to the garden. And so you can see it's quite a narrow plot with a lot of trees on it. Now, some of those trees were going to have to go under the proposed scheme, thus revealing to the occupiers of number 89 the rather, well, some would say unattractive buildings to the side and rear. So anyway, the judge held that these considerations were likewise irrelevant to the interests of the freehold company, and therefore the freehold company, having taken into account matters which it was not entitled to, had unreasonably refused consent. Now, this decision was challenged by the freeholder, the management company, in its appeal to the Court of Appeal, which is the time at which I became involved with one of my colleagues. So the central question that arose on the appeal was whether the management company was entitled to take into account the interests of the leaseholders. And the Court of Appeal said it was entitled to take them into account. It said that the covenant was taken to benefit the whole of 89 Holland Park. Now, at the time that the covenant was taken, it wasn't divided up into, or the title hadn't been carved up into a freeholder and long leaseholds. It had been divided into flats, but they were let out on short-term let. The court also had regard to the fact that the leaseholders had the benefit of the covenant. It also noted that the natural effect of the covenant in the particular context was such that it would be extraordinary if the decision maker could not take into account what the building was going to look like. Now, this comment is interesting because it in principle could apply to any covenant with an approval of plans proviso. The court then said the power of approval wasn't limited to a narrowly drawn view of what the decision maker's property interests were, but rather was much more like the practical benefit test that is applied under Section 84 of the Law of Property Act in the context of discharging restrictive covenants, where one of the questions that can arise is whether the covenant still secures a practical benefit for the covenantee or the party with the benefit of the covenant. And that's a much broader inquiry about the practical consequences. Along the way, the court disposed of an argument that arose from an earlier authority that companies cannot be affected by aesthetic considerations. The the basic thought behind that proposition is that companies don't have a sense of aesthetic taste because they're merely companies. And as you'd probably expect, the Court of Appeal dismissed that pretty quickly. And so the overall result was that the appeal was allowed. So the court decided that the kinds of factors that were taken into account, aesthetic and environmental considerations, were relevant to the decision in principle. Now, it didn't decide that the decision was in fact reasonable in the way that it dealt with those issues. And that question was remitted to the High Court for the next stage of the litigation between these parties, which will consider whether the refusal was in fact reasonable or unreasonable.
Yeah, Tim, can I just cross you there for a moment or two? So
Please.
if I'm a conveyancer then, and I'm looking at this type of scenario, so I've got a client who's buying a flat in 89 Holland Park. Clearly, it's important that I can determine who can enforce a covenant such as this. It's clearly important that if there is a management company that holds the key to consenting or not, it's important to understand what sort of factors and issues that company can take into account. So this decision of the Court of Appeal should give the leaseholder and those acting on behalf of the leaseholder or a prospective buyer a degree of comfort. Do you think that's a fair comment?
I think it is, yeah. Well, if you contrast it with the contrary outcome, which is that the freeholder can't take these matters into account, then absolutely it will provide some comfort. It's by no means established that the freeholder has to take into account the interests of the leaseholders. That's somewhere where this decision simply doesn't go, and I think that's quite a complex question. I mean, in practice, typically buildings like this, where the freehold is owned by a company that is owned by the residents, there will be perhaps a committee or certainly a board of directors that will have to consider these matters, and will have to, if it's doing its job well, will certainly in practice liaise with the leaseholders to canvass their views. But yeah, I mean, it's certainly a positive for a purchaser of a flat in a block like this to know that their interests are relevant, because fundamentally the purpose of the covenant is to protect the amenity of the building in this case and in many cases like it. And so it would be reassuring to know that the leaseholder's views about amenity are relevant. Yeah,
thanks for that, Tim. And then, so going on from that then, if we're now looking at acting on behalf of a management company in this example, or someone who is asked to provide consent in the future, what do we take away from the case in those circumstances, or if acting for such a party?
Well, I think the first thing that you always do is to look at the covenant, and so that was very much the approach of the court here, was to identify what the covenant was intended to do. That was the basis of the court's decision, that clearly it was concerned with what the proposed building might look like, and so you can see that in cases with covenants of this type, where there's a building plot next to residential property, that it's highly likely to be interested with aesthetics and amenity. You can imagine other types of property and other circumstances where you would have a covenant of this type with an approval of plans proviso that isn't really interested in aesthetics. So to think of an example, perhaps not a very good example, but if you think about, I don't know, a plot on a business park or a logistics park or something like that, there might be a covenant against development without prior approval of plans, and that might be much more concerned with practical matters like volume of traffic and the sort of considerations that are relevant to management of that type of property. But I think that illustrates that the starting point is to identify what the covenant is interested in, And that's partly a matter of what the covenant says, and it's partly a matter of circumstances.
Yes.
So having done that, that starts to answer the question of what can be taken into account. And I think the other key takeaway is that the decision maker is not necessarily limited to considering its own practical or financial or property interests. It's entitled to take into account everything that can be regarded as having been intended to be within the reach of the covenant at the time it was taken.
Right.
So as it applies to this type of situation where you've got a building converted into flats or perhaps built as a block of flats, I think the key takeaways are that the usual factors obviously still apply. So matters affecting structure, things that might be relevant to the value of the property, the practical amenity. So, you know, practical matters like access and all of those kind of things are still very, very relevant. But the aesthetics, I think, are going to, in the future, assume a greater importance because of the focus that is being brought to them because of this decision. And so it's one of the things that certainly may be able to be taken into account. How to take it into account, I suppose, is going to be a question that kind of answers itself, because the board of the management company is either going to like the idea of the proposed development or it's not. But it may, if it, for example, holds meetings of residents, sense that there's a certain amount of opposition to the way the building's going to look, and those kind of factors can certainly now, in appropriate cases, form the basis of a valid refusal.
Right. So
the key there, obviously, is appropriate cases.
Yeah. So Tim, I was going to ask then. So again, if we're looking at this from acting as the lawyer on behalf of a management company, it means we've got to look at the bigger picture in addition to usual considerations, and you know, making sure that as a manager, and you make an interesting point about management committee meetings, etc. You know, taking into account and consulting with all the leaseholders, but just looking at everything rather than just simply looking at, as I say on the third bullet point on this slide, the usual considerations. So does this potentially makes the management company and its advisors' job a little harder, and does it make it a little bit more difficult to determine are we being reasonable or not? How would you deal with those 2 points, Tim?
As to whether it makes it harder, I would say yes and no, because this case does not decide that the management company has to take these matters into account and has to consider them. It's obviously up to the decision maker what it considers. Now, it'll be a matter of the relations between the leaseholders and the freehold management company, how it canvasses their views, and the case just simply doesn't go into any of that. So in terms of adding burden to the administrative task, I don't think this decision does. However, it does make it more difficult in that now I think there's going to be a greater emphasis on aesthetics in the way that management companies deal with these types of applications in the future, or there may be, because this decision obviously opens the way to those sorts of considerations being more relevant and more prominent. And that makes, I think, the management company's life more difficult in that it's really difficult to work out how these issues should be approached. And I mean, one of the points made by counsel for Miss Hicks in the Court of Appeal was that the court simply can't adjudicate upon matters of taste. And so one could imagine falling into the bracket of aesthetic objections, someone saying, well, I simply don't like concrete buildings. I don't like glowing glass cubes. I like architecture that resembles middle 19th century stucco fronted villas. And that that kind of point can be made just as a matter of taste. I mean, there are other ways of making the point, and I'll come on to that. But how is anyone meant to adjudicate on matters of taste? Necessarily, they're subjective, and so there's a kind of central difficulty in dealing with these points, in that the objections as they're felt in people's hearts, so to speak, are necessarily subjective. But how are they to be dealt with in a rational, reasonable, and objective way, which is the requirement of a proviso that approval is not to be unreasonably withheld? And that's quite a difficult question. And certainly this case doesn't really offer any guidance on that. I mean, Lord Justice Lewison, who gave the judgment of the court in this case, gave a few very general pointers. And so one of the things he said is that expert evidence may be relevant. And indeed, in this case, there were experts offering their opinion on the architectural merit of the proposal. And you can see that there might be a number of different ways of approaching the question of aesthetics. So, for example, I mean, in some cases, it'll just be obvious that the proposed building is just ugly. But I say it's obvious. What does that mean? It may be poorly designed, poor quality, unsuitable materials, and so on and so on. But those types of objections are likely to lead into are likely to cause the proposal to run into the buffers in other ways, for example, at the planning stage and so on. But there are other questions that can be asked, like, for example, in an area like Holland Park, which has a distinctive character because it was all developed at the same time, is the development sympathetic to its surroundings? How does it relate to the streetscape as it exists at the moment? Does it improve it? Does it take from it? Now, these are all things that architects and architectural experts will gladly opine on. To the layman, perhaps like you and me, they are still matters of subjective taste to some extent. But you can see how you can find a way into these questions to approach what is essentially a subjective question in a more objective way. Lord Justice Lewison referred in his judgment specifically to a case where expert evidence from architectural experts, in fact building surveyors in that case, was accepted by the court and assisted the court in ruling on I think it was a freehold estate management scheme under the 1967 Act, whether what someone had done was reasonable or not within the covenants. And so it's inherently a difficult issue to approach in an objective way, and yet there will be better and worse ways of getting into it. I think it's important to remember that the question that the court will be asked is not whether the objection of the freeholder or the covenantee is a good one or is the right answer. The question is whether the withholding of approval was reasonable or unreasonable. And as we know from other legal contexts, that requires asking whether the decision was one that no reasonable decision maker could have come to. So that tells us straight away that the decision has to be pretty far out there before, in order to be challenged by the courts and set aside by the courts or declared to have been unreasonable. It needs to be pretty noticeably unreasonable. So it's likely that the grey area that's necessarily going to exist for cases that aren't clear, that area is going to be resolved, that will lead, if a case falls into that area, it'll lead to it being resolved in favour of the decision maker, probably. the boundaries of all of this are going to have to be worked out by the courts, and that means, I think, uncertainty for those who are advising people in transactions that involve covenants of this type. And it means that there's probably going to be a measure of litigation.
Yeah. Thanks for that, Tim. So, Tim, let's, if we can, let's change camps for a little while and say, okay, we're doing work on behalf of developers. Okay, what would you say is or should be taken if we're advising developers from this case? So, really, I'm asking you to say, okay, forget about your role with regard to the management company. If we are looking at developers facing similar situations and similar covenants, what sort of approach should we be taking?
Well, I think first of all, it's recognizing what interests of the decision maker may be relevant. So a developer will want to know what does the covenant mean, just as a matter of language, and that's something we're all familiar with. What is it doing here? So the purpose of the covenant, what property interests are protected by it? Now this is where it starts to sort of become a broader question. It's not just a question of who has the power of approval, but what can that decision maker, what can the approver take into account? Now, this case certainly doesn't decide that every covenant with a power of approval of plans entitles the decision maker to take into account the interest of everyone concerned, or even necessarily the interest of everyone with the benefit of the covenant. The decision concerned this particular covenant, and there may be cases where it's clear, or the outcome of construing the covenant is that the decision maker, the approver, has a much narrower range of factors they can consider. So all of these things need to be looked at, and the developer's going to need advice. But I think the key takeaway is that aesthetics are likely to be more relevant in the future than they have been in the past. And that aesthetics probably need closer consideration at the stage where a developer is looking at a potential building plot, at the point where a developer is devising the plans, and where they are submitting them for approval. So at every stage, I think the developer needs to be mindful that aesthetics are certainly shown to be an important factor in a way that people perhaps haven't thought of them up until now.
Yeah, it's a good point, Tim. Very good point. And again, another point that sort of Robert Kelly from Stewart and I have discussed in the past, and it's a point Robert makes. What do you think about the fact that as planning law is relaxed, or is planning law is in a state of flux? Do you think and when covenants become more important in connection with controlling development, we're likely to see more litigation of this nature?
I think that's absolutely right. Yeah, I mean, a lot of objectionable schemes will be knocked out at the planning stage. So as planning law is relaxed, then I think the effect will be that people will rely on restrictive covenants more. Now, whether that will lead to more restrictive covenants being taken, or it'll just lead to greater reliance on the existing covenants, who knows? I mean, driven very much by the market, but it is important, I think, that aesthetic considerations and environmental considerations are likely to be looked at more closely in the future, not just because of this decision, but also because of their greater importance, given what is happening and is likely to continue to happen to planning. And you can see how the two topics may end up being related to some extent, so that the types of matters considered now by planning authority or planning inspectors when dealing with planning applications may become the kinds of things that routinely get looked at when approving plans under covenants of this type. I mean, there's an obvious analogy between the two exercises, and as the courts grasp for a sensible way of adjudicating on the reasonableness of aesthetic objections, planning law provides an obvious analog that the court may have regard to.
Yeah, that's fine. And Tim, where do you stand on this point, the penultimate point on this slide here about testing reaction to development? You know, just explain that for us. So are you saying, you know, that we should look, if we're acting for a developer, at approaching those that can rely on the covenant to gain their stance, to get them to cooperate with them with regard to our sort of scheme? How does that work, do you think, in practice?
Well, I think it's all going to depend on the individual case, and
yeah.
I mean, a couple of broad propositions are obvious. I mean, if you've got a development scheme and you're afraid it might run into the buffers because of a restrictive covenant, one way of avoiding the worst outcome is to try and find out what the risk is in advance by approaching the covenantees or those with the benefit of the covenant and saying, what do you think? So there's an obvious common sense proposition there, but there may be in the individual case a million reasons why that's not a good idea. I mean, if you've got, for example, a fairly old restrictive covenant affecting a plot of land that's subsequently been developed for you know, an estate of residential housing, you might have 100 plots or something, each of which has the benefit of the covenant. And if you knock on every door and say, what do you think of my glass and concrete structure I'm going to put over here? You know, leaving aside the merits of the scheme, a certain proportion of us is going to object anyway, and you might be better off just staying quiet. So it's something that might be considered. I expect it's more likely to be relevant in a case where the category of people with the benefit of the covenant is quite small, they're readily identifiable, and there's an approval of plans requirement that is going to have to be gone through. And so it'll be obvious in some cases that it's a good idea. In other cases, it'll be obvious that it's a very bad idea.
And Tim, I think the other thing that, again, if we go back to this issue of aesthetics, and again, on this slide, we state that aesthetics and environmental considerations are going to be relevant. Again, the important thing is not just to get hung up on aesthetic considerations, as you mentioned earlier, but to think about the bigger picture too. So if there are environmental issues, structural issues, etc., let's not forget that with regard to our deliberations relating to consent. Is that again a sort of something I can grasp and take from your presentation today?
Yeah, absolutely. I mean, one of the big points is, I just want to highlight is that the relevance of aesthetic considerations creates a certain amount of uncertainty because it's not all that clear how you ought to approach them. It's not all that clear how a court would approach them, and in a contentious case, you can see it being an absolute nightmare to resolve. So I think it's important for the decision maker still to look at everything else. I mean, obviously, you're not going to ignore a structural concern if it's genuinely held. You don't want your Holland Park villa collapsing as building works carried out, even if it is to your taste. So obviously, these are things you're going to consider anyway. But I think it's just I think highlighting that if you have an objection on other grounds, I mean, do mention that as well, because first of all, if it's genuinely held, it should be mentioned anyway, or it should be put forward as a reason for refusal. But If you simply rely on aesthetic considerations, you could be opening yourself up to a difficult challenge, or a challenge that is a bit uncertain in outcome and potentially expensive to resolve. So if you get to the point of needing experts to opine on the architectural merit of the potential addition to the streetscape, and that's money you don't need to spend if there's a structural issue, which is really going to be an end of the proposed development.
Yeah. So in this case, Tim, I don't know whether you can answer this one or not, but what sort of expert advice was sought by the management company? What ammunition did you have with regard to considerations or otherwise?
I'm afraid I don't know the answer to that question, because I was only involved in the appeal in the Court of Appeal, and so I wasn't involved below. I mean, I've seen that there was expert evidence adduced on these matters, but it wasn't referred to in any detail in judgment of the judge below, because he said, well, all of this is irrelevant because it doesn't affect the narrow property interests of the freeholder. So I have to say, I don't know.
Right, that's right. Well, Tim, go on, Tim, carry on.
I was going to say there will be people who will be qualified to talk about, for example, the conservation aspects of a proposal. So if you've got a conservation area, or if you've got a historic building next door, you can see that you can see the kinds of experts that you're thinking about. It's perhaps a little bit more different with a slightly more ordinary residential street, with the type of house that surrounds all of our towns and cities. That is attractive, but not necessarily architecturally valuable, and you can see it being slightly harder to find someone who can speak with great authority on the architectural merit of a slightly different looking building being built next to it. But I mean, that's just part of the problem of the process, I think.
Yeah, I guess it is. Tim, that's absolutely brilliant. I've thoroughly enjoyed your presentation today. You've enlightened me with regard to the sort of issues generated by this case. And it's interesting, I'm glad that we've looked at things from the perspective of acting in connection with the purchase of a property of this nature, and also looking at the perspective of the management company too. So that's been really, really useful. Tim, unfortunately or fortunately, you and I now have to see if there are any questions or issues, and unfortunately for you, as the sort of expert in this field, I'll be relying on you with regard to answering any questions. But Stephen, if there have been questions, can you explain to us what they are? And Tim, if you don't mind, if you can stay with us a while longer and deal with any questions that are directed to you. While we're doing that, if anyone has any issues with regard to product relating to indemnity policies, relating to restrictive covenants, or anything else indeed, again, Stewart Title have been brilliant in organising this event today. Again, over the last year, and despite the good times and the bad times, Stewart Title have been with us in connection with providing these, what I think are brilliant events. The likes of Tim coming along today and explaining his viewpoint, his stance, and the law relating to this case is invaluable for practitioners. So again, Tim, thank you. And again, Stewart Title, Stephen and Robert, thank you. Again, Stephen, questions? Are there anything that we need to look at? Any questions from delegates or attendees?
Yeah, thanks both. I think that not having any questions is a fear that Robert and I always have, but we certainly don't have that fear today. If anything, it's the opposite problem. So I think we will crack on. But thank you both, Ian and Tim. Just as a reminder, if anyone would like to submit a question, we have got a few already. Please do submit it through the questions pane in your control panel. If we don't get to it in the presentation, we will ensure that we get back to you at some point in the next week or so, if we have to take it offline. So the first question is from Keith Griffiths, and Keith asks, so in acting for a purchaser of a leasehold interest in a property such as this, is a suggestion that a conveyancer must advise the buyer on whether it is likely to have the benefit of such a covenant and be consulted on an application to approve any such plans in these circumstances? If a conveyancer fails to do so or gets their advice wrong, is this grounds for a negligence claim? I don't know if you'd like to take that one, Tim.
there's a lot to answer there. So is a solicitor acting for a purchase or release obliged to advise on whether they have the benefit of the covenant?
Tim, if I
yeah, go on.
There is the potential for a negligence claim. It depends entirely on the circumstances, but would a reasonable conveyancer be expected to identify if a covenant is enforceable or not? I would take the view, well, yeah, you are. As I always say to practitioners, just because a covenant is noted on a registered title does not mean that covenant is enforceable. It isn't sufficient, in my view, just to sit back and say there is a covenant. If that covenant is going to impact on client objective, then I think we've got to determine if it's enforceable or not. And in circumstances where we're aware of client's objective and there is a covenant that is potentially going to impact on objective, then we could be. I don't know what you think, Tim, but that would be my sort of initial view. But as you say, Tim, there's an awful lot to consider. It's quite difficult off the cuff to say definitely yes or definitely no. But that would be the sort of framework that I would be thinking about if someone were to say to me, has my conveyancer been negligent in this transaction?
Yeah, I would agree with that, Ian. I think that's a good way of getting into the question, is identifying the client's objective. I don't think it can be said that a conveyancer acting for someone purchasing a leasehold property would be negligent in any case where they failed to investigate whether that person had taken the benefit of a restrictive covenant benefiting the freehold land. I think it all depends on the case. I mean, also, I mean, the client's unlikely to suffer a loss by discovering that they have the benefit of something they never realized they had. But, I mean, that's another point. But I think it all depends on the case, and I think the key question, as Ian says, is to identify the client's objectives, and then the next question is what investigations follow from that.
That's right, Tim. I think Tim, to deal with this, if we're just sort of speculating and saying what if, then that would be my view. If Steve, and I forgot the name, posed the question, but if they wanted a sort of definitive answer, if they drop me a note by email, I'll have a long, hard look at it and see, and come up with a definitive answer. But I think that's the position, and I'm delighted that Tim is sort of, in essence, singing from the same hymn sheet there. So, Steve, I hope we've answered it. If we haven't, then the question is more than welcome to drop me a note by email, and we'll have a look at it in a little more detail. Or if there's a specific that requires addressing, I'll try and do that.
Absolutely. Thank you, Ian. Thank you, Tim. And I apologise for throwing you that curveball first. But moving on, we have a question from Tina, hopefully a bit more straightforward. Tina just asked, were the covenants noted on the individual leasehold titles?
In this case, no idea is the answer. I'm afraid I don't know.
Interesting. Okay. Okay, thank you.
Yeah, I'm just trying to think whether they would be.
They don't have to be.
Don't know. That's true. It's true. Yeah, they might be, but they don't have to be. That's the answer, isn't it, Tim? I think. Yeah.
Yeah. Excellent. Thank you. No problem. Thank you. A question from Jane Jones, and Jane asks, kind of interesting, I think, to do with the aesthetics really here. So, how does the argument hold weight with the proximity of the 1960s flats across the road? Now, that's probably opening up a can of worms as well there, but I wonder if you have any thoughts on that.
Well, yeah, I mean, that's the kind of issue which is always going to be relevant. So, I mean, taking it away from this individual case, you can see that if the objection was that here is a nice row of houses that all look the same and perhaps are of historical value, but at one end of the street there's something entirely different and that ruins the consistency of the street. Well, you can see someone saying, well, what does it matter if I put something at the end of the street that doesn't look like it would have looked in 1850 or whenever. So those kind of factors, I think, are always going to be relevant. And so just as it would be relevant in a planning application, for example, when the decision might come back saying, well, you can't build a glass and steel structure in this lovely Georgian terrace. If you're not actually building it in the center of the terrace, but next to a load of other glass and steel structures at one end, then the considerations are obviously different.
Yeah.
Perfect. Thank you. Thanks, Tim. We've had a couple of questions relating to the not to be unreasonably withheld part of this, and so I think they're very similar. So I'll just ask this one from Heather. So Heather says, do you think this case will affect whether not to be unreasonably withheld is implied into the covenant? The consideration of others now coming into the equation could mean that this would have to be implied more often?
Well, this case didn't deal with the question of whether that requirement could be or was implied into this covenant. That was actually the subject of earlier litigation back in 2013, where it was decided that it should be implied. So this case doesn't particularly change that question, or doesn't at all change that question. But I mean, as a general proposition, where there's a power of approval, the first question to ask is it a personal discretion, or is it an objective, reasonable one? And certainly the trend, I think, is to look at most discretions reserved in contracts of any type, including restrictive covenants, as being subject to a reasonableness proviso. It's pretty unusual to find a personal discretion that allows refusals to be capricious and unreasonable. I mean, you do find them, but the circumstances are really unusual, generally.
Thank you. Thanks, Tim, and thanks, Heather, for that question. I don't know if Robert is on the line, but we have something which I would say is really an insurance question, and that is how does the test reaction approach fit in with the concept insurers that the insurers take that there must be no contact with those who may have the benefit of the covenant? Now, Robert, I mean, you and I were talking just offline there briefly, because we've looked a lot recently at the idea of agreed conduct. Obviously, that's quite prevalent in the rights of light market, and whether that, I suppose, is something that insurers would consider.
Yes, Stephen, I think obviously agreed conduct would work really well in that situation, and for the same reason that agreed conduct has become so popular in rights of light, is that developers and property owners don't want to wait and see. They want to know if there's a problem initially. So it would work very well there. Even without that, always bear in mind that what policies say is not to approach people without the insurer's approval. So if you have a policy protecting you, it's certainly worthwhile talking to the insurer to see their view. Depending on the circumstances, that may change. Depending on the strength of the case, that may change. But yes, obviously don't do it without approval, because I've no doubt this litigation was extremely expensive. And if you have the benefit of an insurance policy to cover that cost, you'd be rather foolhardy to risk that not being enforceable in the future.
Yeah, perfect. Thank you, Robert. And a third question here from Heather, just very quickly. Heather asks if the decision maker and the property interest cannot see the new building, one presumes that this would still be a good case of unreasonable refusal of consent. I'm not entirely sure I wrote that out right, but
yeah, it can do. I mean, it all depends on the circumstances. I mean, one of the cases that received a lot of consideration in the Court of Appeal was the case, we all called it the Cryer case. I'm trying to remember. it's full name. But you'll see it in the decision, and that was a case about a development, a housing development, where a restrictive covenant was taken, and the benefited land was the land that the developer hadn't yet sold, and there was a power of approval there. And one of the things that the Court of Appeal said in that case, in the Cryer case, was that aesthetic considerations wouldn't be relevant because by the time that the question had arisen, the developer only owned a small plot of retained land at one end of the estate, and a proposed development at the other end of the estate wouldn't have any effect on it because you couldn't see it. And I think it just all depends on the nature of the property, the work being done by the covenant. So you can see that there are going to be some covenants which purely protect visual amenity as it affects one person. And so that was like, so an example would be the Cryer case where it benefits such land as they retain. In other cases, it might be there intended to protect the character of an estate more broadly. And if it remained enforceable after being sold off, you can see how the decision maker might have an interest, even though they don't own property, which can see the application property. So an example given in the Court of Appeal in the Hicks case was of a building scheme where covenants are taken regulating alterations, for example, and there's a power of approval of plans reserved to the developer, and the developer sells everything off. It may be that the developer could still take into, well, it may be that would work in a different way to the Cryer case, and the developer, notwithstanding that it doesn't own any land that can see the proposed alteration, still is able to take into account aesthetics.
Yeah. Tim, that case is at page 79 of the judgment, isn't it? Cryer and Scott Brothers, 1988. Yeah.
Thank you very much.
Yeah.
Excellent, thank you. And thank you, Helen, for that. We do have a lot more questions. I think we'll kind of come to an end here. Maybe ask one more question. If we haven't got back to you, as I say, we will definitely look to respond to you in the next week. I will share the questions with Ian and Tim, and we'll come back on that. There's one here. I didn't quite understand the question at first, but actually I think it is quite interesting and quite relevant. So Abby Evans asked, if a property has burnt down, is the restrictive covenant still relevant?
Which property? And that's an interesting one.
Well, it depends. I think the simple answer is it depends on the covenant, and it would be a matter of construction whether it applies in that circumstance. So you could have a restrictive covenant on affecting a greenfield site, no building without approval of plans, and that would apply even if you built a house and it burnt down, or you would expect it to. If you had it attached to a building covenant, so like in this case, there was a positive covenant to build a pre-approved house within a certain number of years, subject to effectively a power to vary the plans. In that case, it may be that the power of approval only attaches to the original building. It's all a matter of construction. Sorry, that sounds like a lawyer's way of avoiding engaging with the question, but the answer is it depends.
Yeah, Stephen, again with that, if the question was Heather, if she wants to drop us a note or drop me in, I'll have a look at it. If we're looking at a specific, we might be able to shed a little bit more light. But the sort of general, Tim's quite right. The general question, difficult if not impossible to answer.
Absolutely. Well, look, I think we'll close it off there. Thank you to everyone for submitting your questions. There's been lots of questions there to us, which is always a good thing. Ian or Tim, I don't know if you wanted to have any sort of closing statement or say anything before we end today's session.
Tim?
But
no, I don't think so. I think I've said everything I want to say about this case.
Yeah.
Perfect.
Again,
Thank you.
thank you, and thank Tim for coming along today, and of course thank the delegates, because I appreciate we're really busy at the moment, for taking some time to listen. Thank you all very much.
Absolutely,
Stephen, if
yeah.
I could just interject there, just to say we will be sending a copy of the slides and a link to a recording of the webinar through to everyone who signed up, and that will be out in the next couple of days, so they can share it with colleagues and use it in the future.
Thanks, Robert.
Absolutely, and just to add to that as well, once you leave today's webinar, as is always the case, you will receive an automated message from GoToWebinar. If you respond to this, this comes directly to me, and I can share anything. If anyone has any further questions for Ian, Tim, or Robert, then they can do so by replying to the automated GoToWebinar message, which just leaves me to say, on behalf of Stewart, Tim, and Ian, thank you so much for joining us today, and have a great rest of your day. So goodbye, everyone. Thank you.
Thank you. Bye-bye.
Bye.